Howdy, my name is Brian Foley, and I'm the managing partner here at Houston Criminal Defense Attorneys, PLLC. Today we're going to be discussing drug charges. And so if you have been arrested in Houston or Harris County, Texas, for some type of drug charge, today we're going to be really discussing what that means for you, what's likely to happen initially, and the different types of drug crimes they have. So first off, there's misdemeanor level and felony level drug crimes. Probably the lowest level drug crime that there is called possession of marijuana. And in Texas, marijuana is still illegal. But in Harris County, if it's a misdemeanor case, then the DA's office pretty much has given the word to not accept those types of charges. They're accepted in Montgomery County, just north of Harris County, and a lot of other places in the state. But Harris County DA's office has decided not to take those. So if you get caught with a little bit of marijuana in Harris County, Houston, you're probably going to be okay. I think they're going to maybe take it away from you, but I doubt they're going to arrest you or have a criminal case. Now, if you have a growing operation in your house, it's greater than 4 ounces, less than 5 pounds, they're going to charge that as a state jail felony, and they will still charge that offense. But the first two things I would say, if you were to call me and you had a drug case in Harris County, the first things I would tell you is probably your case is a felony case likely. Now they do have misdemeanor drug cases for controlled substances under penalty group 3. That's normally hydrocodone. It can even be like 800 milligram Advil, ibuprofen. You do have to have a prescription for that, or it can be a class A misdemeanor. But more likely than not, it's going to be for something like hydrocodone or Xanax. And those are misdemeanor cases. They get filed in the county courts and normally not too difficult to deal with. I would expect if you've got no criminal history, we're going to be trying to get that case worked out for you in a way that you can get it off your record eventually. Now, as a lawyer, I have to tell you, there's no guarantees. Nobody as a lawyer can make any type of ethical guarantees for you. But anyway, what we've got and what I normally tell people is if your case is a felony drug case, then two basic things. One, judges regularly impose bond conditions, which require you to report to pretrial services and be drug tested just like you're on probation, even before you have been convicted. And a lot of people tell me, Brian, isn't it where in America you're supposed to be innocent until proven guilty? Well, that's true. In voir dire or jury selection, we often go over what's called the presumption of innocence, and that is a real legal term. It is the law in Texas that you are presumed innocent until proven guilty beyond a reasonable doubt. But judges will still impose these bond conditions, and they're authorized to under Chapter 17 of the Code of Criminal Procedure. So one of the things that they're going to make you do is report once a month, trying to make sure you stay in contact with basically the probation or the pretrial services department. But they can do other things like electronic monitor. Now for a drug case, I would say we're really less likely to get electronic monitor unless you had like 4 kilos of methamphetamine or cocaine, something like that. Then we could be looking at an ankle monitor. But most of the time in a drug case, they're just going to be testing you for drugs. They're trying to make sure that you're not using while the case continues. And then number 2, the second part, it is possible to avoid jail time even if you feel like the evidence against you is strong, even if you feel like they're going to be able to prove that they had the legal right to search your vehicle, if it was found in your vehicle or your home, if it was found in your home pursuant to a search warrant. But the sooner we get started on reviewing the evidence in your case, the faster we can get you a final answer as to what we think is going to happen in the case. So let's talk about the different penalty groups for drug cases in Houston and Harris County. We've got penalty group 3, and normally for a misdemeanor, this is going to be less than 28 grams. Okay, it's one of the lowest drug charges that you can get in Harris County. And again, it's normally for hydrocodone or Xanax. Second most common one we get is possession of a controlled substance, penalty group 1. And penalty group 1 is things like cocaine, heroin, fentanyl, methamphetamine. Those are the most likely. Now, we get a lot of this, it's called penalty group 2. Now, penalty group 2 is more likely to be THC than anything else, but I would actually say the most likely charge to get filed under penalty group 2, even though it's incorrectly filed under penalty group 2, that would be possession of MDMA or ecstasy. It's called 3,4 methylene deoxymethamphetamine. And that drug, the police will look at these pills and they'll see a pill and they think it's ecstasy. They're pretty sure they've seen these pills before. But really what's happened is in the last 5 years or so, people are putting methamphetamine and disguising it as an ecstasy pill. So most of these ecstasy pills are not testing positive for 3,4-methylene deoxymethamphetamine. They're testing positive for regular methamphetamine. So they're improperly charged as penalty group 2 offenses. They should be penalty group 1, because if it's regular methamphetamine, that's penalty group 1. If it's 3,4-methylene deoxymethamphetamine, then it's going to be penalty group 2. So now, what is the most likely substance to fall under penalty group 2? Well, you'd be looking at something like Adderall, like amphetamine, or you would be looking at THC, any type of tetrahydrocannabinol. And there's a lot of debate about whether or not that is legal, if it's Delta 8, if it's Delta 9, if it has less than a 0.03% concentration of THC. Well, if it's that last one, the 0.03 concentration, if it's Delta 9 THC we're talking about, then the law is going to prevent that from being prosecuted in most instances. Now, does it mean you aren't going to get arrested? No, you very well can be arrested. But that's something, if you've got a THC case, we want to take a close look. We want to request laboratory analysis of the marijuana or other substance that might have had THC in it. And if it is marijuana, then they should be charging that as just a marijuana case based on the dry weight of the marijuana. If it's an oil or a THC wax, they may charge it under penalty group 2. All right, now one other thing to talk about here before we let you go, and that is when we're talking about drug charges, one of the most common things we see when there's a lot of drugs, a lot of weight to the drugs, is they'll charge it as possession with intent to deliver, or they may charge it as manufacture and delivery of a controlled substance. So a good prosecutor is going to charge it always as possession with intent to deliver, because it's easier to prove that you were in possession of something with the intent to give it to someone else, rather than to prove that you actually gave it to somebody else. Actual delivery cases normally either have a confidential informant or something like that, so video evidence of the delivery taking place. You know, that's a lot harder than saying, okay, well, we pulled this guy over. He had scales, baggies, and a ledger about the times that he had sold it in the car. That's what a prosecutor is looking for in a manufactured delivery controlled substance case. So the way that we fight those most commonly is trying to attack the reasonable suspicion or the probable cause to search for the evidence that they're going to try to use. Now, depending on the substance, we may look at the laboratory analysis. But again, most of our drug cases are handled by checking out the probable cause and reasonable suspicion. And that's always the first step when you've got a criminal case. So I hope this has been helpful to you. If you've been charged with any type of drug crime in Houston, Texas, talk to an attorney immediately. It's definitely in your best interest to talk to an attorney, certainly before you talk to the police. So thanks again. And this is Brian from Houston Criminal Defense Attorneys, PLLC. We'll see you next time.